On January 20th, 2025, President Trump issued Executive Order 14160, protecting the meaning and value of American citizenship. This order reflects the original meaning of the 14th Amendment, which guaranteed citizenship to the children of former slaves, not to illegal aliens or temporary visitors. Multiple district courts promptly issued nationwide or universal injunctions blocking this order, and a cascade of such universal injunctions followed. Since January 20th, district courts have now issued 40 universal injunctions against the federal government, including 35 from the same 5 judicial districts. This is a bipartisan problem that has now spanned the last 5 presidential administrations. Universal injunctions exceed the judicial power granted in Article 3, which exists only to address the injury to the complaining party. They transgress the traditional bounds of equitable authority, and they create a host of practical problems.
I mean, that's a lot of words, and I don't have an answer for if one thinks. And, you know, look, there are all kinds of abuses of nationwide injunctions. But I think that the question that this case presents is that if one thinks that it's quite clear that the EO is illegal, how does one get to that result, in what time frame, on your set of rules, without the possibility of a nationwide injunction?
On this case and on many similar cases, the appropriate way to do it is for there to be multiple lower courts considering it, the appropriate percolation that goes to the lower courts, and then ultimately this court decides the merits in a nationwide binding precedent. You have a complete inversion of that through the nationwide injunctions where the district
So, General
courts
Sauer, are you really going to answer Justice Kagan by saying there's no way to do this expeditiously?
Well, I'll refer to my former answers. Rule 23 provides the tools to do so, multiple injunctions.
But you resisted Justice Kagan when she said, could the individual plaintiffs form a class?
That has never been briefed in the court below. I do not concede that we wouldn't oppose class certification in this particular case. There may be arguments that this case is or is not appropriate for class certification.
This court should deny the emergency application because this injunction was properly designed to ensure that the states would get relief for our own Article 3 injuries, as we suffer significant pocketbook and sovereign harms from implementation of this executive order, including from the application of this EO to the 6,000 babies born to New Jersey parents out of state every year. The U.S. prefers alternative approaches for granting that relief, alternatives it never raised in the district court below. But its approach would require citizenship to vary based on the state in which you're born, or even turn on or off when someone crosses state lines, raising serious and unanswered administrability questions, not just for the federal government, but also for the states. And it would offend the text and history of the Citizenship Clause itself. Since the 14th Amendment, our country has never allowed American citizenship to vary based on the state in which someone resides.